discuss the regulations that may be needed to be implemented pursuant to Assembly Bill 1308. All public comments should be addressed to this agenda item, and please ask that your cell phones be turned off or turned to silent. And we will be taking comment from everybody as we come along, but we do ask that everybody sign in the back to help us, and then also if you have comments, to fill out a public comment slip. That those can be collected by Destiny when she returns. She's also be here in just a little bit. She's bringing some more copies of the actual, it's the bill, right, correctly. So she'll be here in just a few minutes. So today's purpose is to help us identify what areas need regulations and what those regulations might need for the staff here to work on. We'll go ahead and start off with the board sort of has identified two areas that we believe there's probably a need for regulations for, and one area that we do not necessarily believe needs regulations, but we need input on it. So regarding that, it's on, we believe that we probably need regulations on pre-existing maternal disease or condition likely to affect the pregnancy. And then we also believe we probably need the board shall adopt regulations pursuant to the Act, Procedure Act, Chapter 3.5, commencing with Section 11-340 of Part of A1 of Division 3, Title 2 of the Government Code, specifying conditions described in subparagraph A of paragraph 1. And then the other thing that we would be looking at, and we'll take the first one first, is whether or not there is a need for regulations regarding Section F, which is a midwife authorized to directly obtain supplies and devices, obtained and administer drugs and diagnostic tests, ordering tests, and receive reports that are necessary to his or her practice of midwifery and consistent with his or her scope of practice. So, so if you have speaker slips, you can give them to Destiny, who's going to stand up first and raise her hand. So that would be appreciated. So we will pretty much, we have one speaker slip already from Teresa McLean, and so we would like to get, if she could come up and present her comments, that would be good. Well, she might not be here.
I just don't know which way to go.
Come up to either one of these tables so we can listen to you.
Okay. Hello. My name is Teresa McLean. I am the Vice President of California Families for Access to Midwives, a consumer organization formed in part to respond to AB 1308. And from nothing, we became an organization of over 3,000 people in this last year. And the families of California want to continue to have input on the language that becomes the regulations in the next steps. And since I'm new to this process, learning more about what the next steps are and the process that will be happening, I'll be conducting a community meeting about our process next week. And actually I'll have to step out in a few minutes because I'm going to be interviewed by a radio station about the process as well, and about AB 1308. We feel strongly that California mothers need to have access to midwives, that the regulations need to reflect the needs of the families and the women who are asking for care from midwives, and that we need to make sure that the language is as broad as possible to allow families to easily access midwives. and not make it overly burdensome for them.
Okay, thank you. We'll go ahead and give you an overview of what the regulatory process is like.
Sure. What
Microphone.
microphone. What the plan is we're gonna take down input and ideas today, and I will have the privilege and honor of helping to create a draft of language that will be in our format of regulations. We believe that we will be having another interested parties meeting for input on the actual proposed language. And once there's as much consensus as possible, we will be taking that language before the full Medical Board of California, and they have input and get to vote whether that language goes forward in the regulatory process. If the board approves the language that's been proposed, then there's another layer of documents that are prepared, financial impacts and initial statement of reasons for why the regulations are necessary. And that goes to the Office of Administrative Law. And there's a lot of things that have to be in order for a regulation to ultimately be approved. But once it's published, then there's a 45-day comment period, and people from all over, and basically other interested parties, can support or oppose it. And they send in written comments. There's a public hearing on the actual language being proposed, and they can make comments there. And we have to address every comment that's made, either accept it or reject it, and with reasons. And it continues on until there's a period where the comments are supportive, or we have reason to reject the comment. And it goes through Department of Consumer Affairs for review, and again through administrative law, and ultimately it gets adopted and put into play.
Thank you. I did want to say that almost several times a week, I'm getting phone calls from both families and from midwives saying, how does this particular piece affect me, specifically the likely to affect pregnancy, diseases that are likely to. So I get calls almost every week about that. I'm getting calls both from midwives and from families saying, can you give me more clarity? And I said, the regulatory process is happening, and that's where clarity will come. But we do get phone calls all the time about these particular issues, and those two in particular.
Okay, thank you.
Thank you.
I forgot to introduce myself. So I'm Curtis Warden. I go by Kurt. I'm the Chief of Licensing of the Medical Board. And this is Natalie Lowe. She's our licensing manager over the midwifery program. And this is Carrie Webb, and she's our legal counsel. So we're here to get the information that's going to come forward, and then we'll be the ones working on drafting the languages that we will. And as Ms. Webb stated, we probably will need another interested parties meeting before we bring this to the board. So we're actually a little bit closer to what we actually need versus going to a hearing and then not finding out we're missing something or something's not quite right. So it will save us some work in the long run and make our regulatory process a little bit smoother. So if we could have somebody, do we have any other speaker slips or somebody who would like to make a comment about what areas or what you might want to propose for a regulation regarding the any pre-existing maternal disease or condition likely to affect pregnancy?
I'd also like to mention that in the MAC meeting earlier today, it was addressed the passing of AB 1308, and that part of the implementation for the medical board is to notify all of the licensed midwives in California of the passing of the bill, which goes to what Teresa mentioned, and that will be providing some outreach on the actual law. So that will be going out shortly.
Karen Ehrlich, licensed midwife. I would just like clarification on what this A1 Division 3 subsection subparagraph, what is that?
That's actually the process that is authorized for us to do the regulatory process.
I see. Thank you.
I sort of said that as a condition, but that's really not the condition.
That's, yeah, okay.
Ms. Constance?
Hi, Constance Rock for the California Association of Midwives. So we would like to see our regulations basically stay the same, except for amendments that reflect the changes in AB 1308. So, for example, breeches, twins need to be reflected in the regulations. And as far as prior uterine surgeries, we think that's something that needs some special attention, and we are working with stakeholders to come up with a solution that we can all live with, and we will make a proposal once we come up with that.
Okay. All right, thank you.
Thanks for doing that outreach and making that effort. It will help a lot. Yeah, you're welcome.
Faith Gibson, California College of Midwives, and I'm pretty much reiterating Constance's comment. In particular, in our current regulations, page 7, which is the criteria for client selection, that seems to have, that has served us very well as a guideline as to identify those mothers who either were not appropriate choices for. It's in the regulatory package on page 7, that either were not appropriate choices or who needed to have some kind of physician evaluation before that would be considered. So it's the current the regulations that we already have, but in particular the criteria for selection, which is on page 7. Thank you.
Thank you. So we want to try to get some proposed language, if any is needed, and for what might be needed in regulations regarding any pre-existing maternal diseases that might not be already in regulation. And we could.
Marceline. I have a question. In the sentence, any pre-existing maternal disease or condition likely to affect the pregnancy, is that the scope of the midwife to decide whether that is a disease or a condition likely to affect the pregnancy? Or will there be a list of things that we need to consult the physician about?
Well, that's what we're here for today.
That's the key point. Because again, if we are experts in normal, we'll know what is abnormal. But each midwife probably feels, as I do, that that's best determined by the midwife. And if we write any regulations that restrict which conditions or diseases might be referred to a physician, then someday those are going to be outdated or they're going to be changed. There'll be a need for more regulatory writing, and so I would urge that we do not make a list, and that a pre-existing maternal disease or condition likely to affect the pregnancy be defined by the midwife taking her into care. The other thing to realize is that I've been practicing for more than 30 years. I've never had anybody with a pre-existing condition likely to affect the pregnancy come to me and say, hey, I have heart disease, but I want a home birth anyway. Or I'm insulin-dependent diabetic, and I think this is the perfect place for me to have a baby is at home. These people don't show up. Women take their own health care seriously, and midwives take the safety of their mothers seriously, and would probably, should somebody come and say that to me, I'd say, sorry, I'm sorry, I just don't take drug-dependent diabetics, I just don't take people who are more able to be cared for in a higher level setting, and I think that our regulations do us disservice when they become a cookie cutter cookbook approach. Thank you.
Thank you. Ms. Barron?
Carrie Sparrow, unlicensed midwife. So I'd just like to note for everybody present that there is a work group going on between ACOG and California Association of Midwives to flesh this out. I think that there's currently general consensus that the current standard of care laundry list of pre-existing conditions that we've all been working with since 2005 is still acceptable and applicable here, and that we don't really need to edit it except where it applies to prior uterine surgery. And if I'm understanding correctly, CAM and ACOG are in process of working out what that might look like and what referrals there might need to be or not be as we move forward with that. So just for expediency, I just like to put it out there that it's already, there's fairly good consensus to just use what's in the standard of care.
All right, thank you very much for that. Any other comments on that?
Leslie Nelson, licensed midwife. In the standard of care that we currently operate under on page 8 is the client's right to self-determination. Is that going to be removed at this point, where the client can make a written, informed refusal after having been informed of the risks and benefits of whatever condition they have to transfer out of care?
There are some things that a woman is not going to be able to give consent for.
Okay.
And that's fleshing out what those conditions are.
So is that this passage going to be changed in the standard of care?
Yes.
Can I just follow up on that? Something that wasn't clear to me earlier, and I think it is clearly not clear to other people here, and that's that the section of the law that created our standard of care has now been repealed. So as of the 1st of January, the standard of care is no longer part of the law because the law that created it has been struck. So nothing in the standard of care will continue to apply after the 1st of January, am I correct?
Yeah, it's correct. It actually hasn't been struck yet, but what happens is the statute overrules the regulation, and because the statute has been changed, it's no longer applicable in its current form.
Well, the part of the statute that actually created the standard of care, the section that we weren't ever able to implement in terms of physician supervision, also contained the clause that said adopt an appropriate standard of care, and that is no longer part of the law. It was line struck, right?
Right.
Yeah, okay. So in answer to her question then, I'm correct that
Yes.
client's right to self-determination, that clause is gone.
Correct.
Okay. I just want to be clear for everybody so that everybody understands that
Yes,
after the first of the year, no longer applies.
Exactly.
There are going to be some things where after a midwife refers the patient to a physician, that then the physician can okay that the woman continue to be treated with the midwife. So.
Karen, licensed midwife, I understand what Carrie Sparrow just said. However, I would simply like a point of clarification about where in AB 1308 it states that. Because I don't read it there, so it just is a puzzle to me.
I can show you my highlighted version of the law. It's a little easier to see.
Okay.
And for those of you who are looking at your packet, it's section 2507, subsection F, which has been actually
Side by side, you see
removed and
strikes.
right, so that and there's no and will not be the current
So it was
subsection. Well, I guess if you don't have
something new.
So the section that has been struck said that the board shall not later than July 1st, 2003, adopt in accordance with the Administrative Procedures Act, regulations defining appropriate standard of care and level of supervision required for the practice of midwifery. And that's all been struck out. So that is the area that is the reason why that one section of the regulations is no longer valid regarding the standard of care. All right, so if there's no further comments, we'll take the comments on the back.
I have a question. So if new regulations are not written before January 1st, which seems unlikely that they would be, how do we know what we're supposed to be doing and not doing? I mean, we're real clear about breeches and twins, post-dates babies, but what about everything else that was in regulation if that's no longer valid? Do we just follow what we used to have in our standard of care until they're rewritten?
I would say that the standard of care still would be a good tool to follow, with the exception of what Ms. Berrybon suggested, which is the area regarding the VBAC. So I don't foresee a problem with the rest of it. And we will, I mean, you still have the community standard of care, and that's sort of written. And so even though it's not in regulation, that document was produced, and that will probably either be recreated somehow, or the board will be presented to the board to adopt it as a guideline for future use, similar to how we do guidelines for pain medication and prescribing. So, and that is sort of an option that the board is looking at. So,
Okay, thank you.
I think the starting place is to look at the changes from 1308 and make sure that regardless of what the standard of care document says right now, make sure that what's been implemented in 1308 is being followed. That made some specific changes.
Right.
And then the community standard of care, unless it deviates from those changes from 1308, is what you still follow.
and that's basically in your old standard of care.
Point of clarification, Carolyn Ehrlich, licensed midwife, that Mr. Warden said that the standard of care is not in regulation, but it is. Our standard of care was adopted as a regulation by the medical board.
Correct, but it's no longer in existence after January 1st.
I see, so you're calling it just simply a community standard of care since AB 1308 has altered its status?
I'm saying it's a good way to still use that document as a community standard, with the exceptions of where the areas of the passage of AB 1308 may take away that area, parts of your standard of care. So there's your standard of care that was in regulation, it no longer actually meets all the requirements of current statute. And so therefore, those areas, as Ms. Webb stated, you would not want to cross into those areas, because this new law prohibits that. And so you can use a lot of what's in the standard of cares as your community standard. And as I said, we'll probably be presenting maybe something like that as a modified thing to the board if we believe that is the best way to go. As a guideline, similar to we do with pain prescription management, guidelines that we have for physicians. We don't have it in regulation, we have it as a guideline. So that is something that the board will be considering. So.
Okay, I will add my voice that I would hope that whether or not our standard of care is accepted as regulation, that it remain in essence exactly what we have been living with since 2005. This was arrived at with a great deal of comment and input from all over the state. It was arrived at through negotiations within the medical board framework by medical board staff, ACOG representatives, California Association of Midwives representatives, and licensed midwives throughout the state as something that is appropriate for licensed midwives to have regulation that fits how we work.
And there is now a section of that.
I understand. I recognize that section, I'm just saying, I think I said in essence.
Right, and I don't disagree with that.
Yeah,
I
I'm
don't think
just
anybody disagrees with that, so
adding my voice.
that's fine.
Because I do that.
I'm Kim Kirkmeyer. I'm the interim executive director, for those of you that don't know me. I just want to kind of touch on what the medical board's intention is, and obviously we haven't truly fleshed out everything as well in looking at this, and so we will continue to do that with legal counsel's input as well as obviously with interested party input. But I did just want to clarify one thing, kind of Mr. Warden kind of put out there in essence, but I want to kind of just make sure that everybody's clear on what we intend to do at this point. And this was actually just in discussion with individuals who are familiar with this. So what our intention is to write the regulations, because we really do have to talk about that maternal existing presence that's there. So we will put that in regulation, but your standard of care document, we couldn't agree more that that's a great document. And so we don't want to take away from that. So kind of as Kurt alluded to, we do want to go forward with putting that in there. We wouldn't put that in regulation, but what we would do is we would go ahead, do the regulations that we need to according to what the law states now in AB 1308. And then we would go ahead and put the guidelines with changes to bring them into compliance with the current AB 1308 changes. We can send those to the board for adoption as guidelines that we would put onto our website. So they would in essence be the guidelines for licensed midwives right now. So we wouldn't be taking away from your document except for where it doesn't comply and comport with the changes of AB 1308. So is that understandable? We really don't want to take away from it, so. Okay.
Ms. Kirkmeyer said it much better than me. Dr. Byrne? That's okay.
Greetings, my name is James Byrne from Santa Clara Valley Medical Center. For this goal to be reached, I think that the most important thing everybody should try and emphasize is transparency, clarity, and a focus on safety for women and their children. As such, I feel that ambiguity or a lot of individual determination of these conditions might inadvertently divert progress toward that goal. If there is openness to consider potential guidelines for what would be considered conditions, would recommend that this group evaluate guidelines which were developed in collaboration between the American Academy of Pediatrics, ACOG, the American Academy of Family Physicians, I believe ACNM. The guidelines for perinatal care were most recently republished in 2012. These are guidelines, and they identify a series of conditions for women or children, which would, per the guidelines, have a recommendation for an OBGYN consultation or evaluation, or even an evaluation or consultation with a maternal fetal medicine specialist. These guidelines do not require transfer of care, but they make it clear that there are some types of conditions which, if they are present, make it both predictable but potentially preventable to have a poor outcome for a mother or child. An example given previously was a woman with insulin-dependent diabetes, and there are other similar conditions, which if they're present, most women will do fine with no interventions. But they do, again, make it both predictable and potentially preventable to have harm. So a U.S. source would be the Guidelines for Perinatal Care, edition 2012, which are very clear and not dictatorial. An alternative that I'd recommend would be World Health Organization definitions for normal pregnancy and conditions which would warrant increased antenatal care. Thank you.
Thank you.
I'm Paula Schneebaut, licensed midwife, and I have a question for clarity. As I've been sitting and listening, I understand that there would be conditions that would call for referral to a physician specializing perhaps in obstetrics and gynecology to give a report about the appropriateness of that woman continuing care under a licensed midwife and consideration for a home birth. Would that not also then perhaps apply to twin or breech pregnancies? If I had a client who, for example, was pregnant with twins, and I consulted with an obstetrician who said that her situation did not indicate a likelihood of adverse outcome, could then she, if she chose to exercise her right of choice for place and method of birth, consider a home birth of a licensed midwife?
No. I would have to say that that would not be permissible because it has to meet the following conditions. There's an absence of both of the following: any pre-existing maternal disease or condition, significant disease arising from pregnancy, that there is a singleton fetus, and that there's a you might have to pronounce me, help me with the pronunciation, cephalic presentation. So
even if that mother wished to exercise her right for determination of place of birth, and even if I got a consult with an obstetrician who said that she would not be expected to experience an adverse outcome by choosing home birth, we would not have the opportunity to provide her with that option.
Not with the way the law is currently written.
Okay, thank you.
Conferring.
We're all so wordy. I'm sorry, Dr. Burns, I didn't mean that we shouldn't follow the guidelines that we already have enumerated here about choosing people who could make home birth a success for themselves and for their babies. We have plenty of guidelines, I just didn't think we needed more. But the other thing that I want to bring to the board's attention specifically is the fact that we may, by regulation, we may, by law, get rid of the protections and the rights of women on paper, but they will not voluntarily give up those rights. And those women who do not meet our criteria and still wish to birth at home will now do so more unsafely and do so without the guidance of the midwife who could have made a difference in their care. You cannot simply take a paragraph out of a regulation and then have women say, oh, I'm sorry, I'm not going to do what the paper says, I'm going to do what the paper doesn't say. I am going to you can't take away a woman's right to self-determination. And furthermore, there must be somewhere some guiding principle in medicine, let alone in midwifery, that says women have the right to choose their own place of birth. I think it says so in one of our laws, but even if it doesn't, you can't legislate away people's right to self-determination. Thank you.
Thank you.
So at the risk of being incredibly unpopular, I like to make a distinction here. And the distinction is that nobody has legislated away women's rights. What has been legislated is the right of a midwife to provide certain types of care. And those two things are very distinct. No medical professional is allowed to waive their scope of practice because the client in front of them wants them to. If women want to change what they are allowed to do, where they're allowed to birth, and who they're allowed to birth with, those women, and that can include midwives, need to come together and lobby for those changes separate from midwifery law, or medical law, or podiatry law, or any other law that governs a specific provider. And the avenue to do that through is the California Families for Access to Midwives. That's a consumer group that individual women can join and midwives can join to band together to reclaim and preserve reproductive rights for all women. But you need to recognize that there's a complete difference between the laws that govern licensed midwives and what self-determination for a particular woman looks like. They're two different things.
Thank you.
Sorry. Sorry. I guess this just means we need some other regulation then that deals with abandonment of clients. Because should we discover a person who refuses, who is in our care, who comes up with a condition, say undiagnosed twins, which is very rare anymore, but especially undiagnosed breech, or any other condition, and or they get to 42 weeks and they say, I'm not going to the doctor. Or we show up at a hospital and they say, we don't have room for you. There needs to be some sort of mechanism for us to deal with the abandonment issue. We can't just stop care because some condition has arisen. That's, I'm sure, violates many, many ethical standards. And so there must be a mechanism that addresses how long we can care for someone if there's nowhere else for them to go, if no one else will take them on, if the person who is under our care refuses our suggestions, and that's the giant issue for me. Thank you.
So, as I said, we sort of need regulations, and we understand that CAM and ACOG are working together with that. I think at this point, it'd be good for the staff here to wait on preparing any proposed language until we get the feedback from ACOG and CAM, which we would present at the next interested parties meeting. And I have another comment that's a little bit, is that we can't address every law, every situation and regulation that may come up, or we can't prevent people from breaking laws and regulations. So we are here to provide the best consumer protection available for most situations. There are always going to be something that comes up that might not fit our current law or regulations, and that's not the intent of the law or the regulation process. It's to apply to the general mass versus an individual who is choosing. It's just like if I go and choose to break the speed limit, I get a ticket. I'm not supposed to be breaking the speed limit, but I do sometimes. So we make choices, and that's something to consider. This is not going to cover every possible situation that might come up. I mean, talking about healthcare, and healthcare has lots of unexpected things that come up. So if we are sort of done, I think we'll go ahead and move forward to the next possible area that we might need regulations, and that would be the area where a midwife is authorized to directly obtain supplies and devices and obtain and administer drugs, diagnostic tests, ordering tests, and receive reports that are necessary for his or her practice of midwifery, consistent within the scope of their practice. So I do not know if we need regulations for that. I think it's sort of written in a manner that is probably in a form and statute that will evolve with the practice. So as far as any other practice of medicine, you got to be careful about what we put into regulations so that it doesn't evolve with the practice of midwifery or any other thing. So I do not know we need something, and that's why we're here to find out input from the midwifery community and the public. So
I think to kind of get us started here, if the board decides to retain the standards that are currently in the standard of care, Standard 11 actually speaks to that. The licensed midwife shall order or administer only those prescription drugs and procedures that are consistent with the licensed midwife's professional training. I think retaining that language covers everybody, and in those, what I would hope would be non-existent, but certainly rare instances where a midwife is non-compliant with that and there's a complaint made, then the board can move forward in that direction without there being a list of actual drugs and devices that can be obtained as those requirements and standard of care within the community changes. And we don't want to have to recreate regulations all the time to update that.
thank you very much.
Yeah, just stay there. Diane Halser, licensed midwife. I do agree with Carrie that covers that, but I would like in particular to have maybe something written out regarding the diagnostic tests, and in particular ultrasounds and genetic testing. Because at least in my area, that's where we have a big problem is that the ultrasound places sometimes won't take our order. So if we could flesh out something, even just a parentheses that says, interpret those screening and diagnostic tests, including ultrasound and genetic testing or whatever, the community wants to put in there. But I would like to see that specifically spelled out in this little paragraph. I would like to see ultrasound written in there under diagnostic, in parentheses under diagnostic tests.
Okay, thank you for your comment.
We really think that the statute stands alone on that. It clearly gives us authority to order tests and devices, and I don't know that anything more is needed in regulation, and we would prefer not to have any list of what we can and can't do, but to continue to do what we have been doing, which is only using that which we've been taught to use, and that's community standard.
Thank you very much. Are there any other further comments? All right, so I think that will conclude our meeting if there's no further comments regarding that, so that staff can move forward.
We should just check, is there any other part of 1308 that people feel need regs?
I think the board is actually directed to create a form for the hospital transfers. And I'd just like to say that I know that there's already an independent work group going on to create that, and we'll be forwarding something to the board that might be able to be used there.
All right, we appreciate that. Thank you very much.
No.
Do you have an idea of what our timeline is for the next interested parties meeting, so that everybody can kind of be on the same page? I mean, are we talking 6 months, are we talking 6 weeks,
no.
are we?
I would like it within 6 weeks, so I would like the information from CAM and ACOG as quickly as possible, because I would like to be able to say this has been vetted at the interested parties meeting so that we could present it to the board as for permission to go forward with the reg. So that's my goal, and our board meeting is in February 6th and 7th. So.
Oh, wow. So will there be, at the next interested parties meeting, will there be some proposed language around this by then?
I'm hoping.
Okay, and then we can discuss that, the language that you'll come up with for the next interested parties meeting will be based on today's meeting and what has been talked about here. And then at that meeting, then we can flesh it out more, add, detract, whatever, and then you can go forward from there to the board?
Yes.
Is that the plan? Okay.
That's the goal, because that way we can get the regulation process started as quickly as possible. Unfortunately, it would, if we can get that information within the next 6 weeks, so that staff can prepare an interested parties meeting, so we can get the input on what we put together based on the information that was provided to us, then that will make our regulation process much smoother. But what I'd like to do is be able to ask the board for permission to proceed with a regulatory hearing based on what I'm going to be providing them at the board meeting. And hopefully we'll have most of it vetted out until we actually have the regulatory hearing and get comments at that point.
Okay, so we're looking for another interested parties meeting by the middle of January then?
Hopefully, yes.
Okay, thank you.
Ambitious.
So, okay. Well, I would like to thank all of you for coming today, and thank you for your assistance. This concludes our meeting.